Oyez, oyez. The United States Court of Appeals for Veterans Claims is now in session. The Honorable Michael P. Allen presiding. All who have business before this court, draw near and you shall be heard. God bless the United States and this honorable court. Please be seated.
Good morning. I'm Judge Allen, and to my right is Judge Falvey, and to my left is Judge Jaquith. We are convened today to consider argument in the matter of Richard Leahy versus Dennis McDonough, Secretary of Veterans Affairs, case number 23-1547. With counsel, beginning with Appellant's counsel, please enter your agreement for the record.
Good morning. My name is Suarez. I represent Mr. Lee, and with me, a second seat, is Jennifer Healy.
Welcome to both of you. Secretary.
Good morning, Your Honor. Shannon Leahy on behalf of the Secretary. With me at counsel table is James Cowden, Deputy.
Nice to see both of you. Thank you. And Appellant's counsel, I understand you want to reserve 10 minutes for rebuttal. Is that right?
Yes, Your Honor.
We'll make that happen, and you can begin when you're ready.
May it please the court. Mr. Lee had cancer for almost 6 years before he filed a claim because the VA knew he had cancer, but it didn't tell him. This began in July 2010 when the VA ran tests that showed Mr. Lee had chronic lymphocytic leukemia, but no one told him. In July 2012, Mr. Lee met with a VA specialist, and this specialist made a deliberate decision to withhold information from Mr. Lee. This specialist wrote in his notes, "I did not use the term leukemia," told him that maybe in 20 years he would need further investigation. The VA doctor's decision to not use the term leukemia mattered. Mr. Lee is a Marine who served in combat in Vietnam and was exposed to Agent Orange. Under the rating schedule, the VA rated any stage of leukemia at 100%. But it wasn't until 2016 that a VA oncologist told Mr. Lee he had leukemia. Mr. Lee immediately filed for VA benefits, and the VA granted him 100% disability. Mr. Lee currently has an effective date of January 2015. But this effective date is based on when Mr. Lee made his claim. This effective date does not account for the fact that the VA prevented Mr. Lee from filing his claim for almost 6 years when it did not tell him he had leukemia.
Could I jump in here because we've got the facts now? So one of the arguments you make is that the VA should be equitably estopped. Is that right?
Yes, Your Honor.
So, well, the Taylor decision from the en banc Taylor decision from the Federal Circuit is fractured. There were 13 judges who sat on that case, and 8 judges on the Federal Circuit, the superior to us in the hierarchy, said the following, quote, "We therefore hold that under Richmond, equitable estoppel is not available to override the claim filing effective date limits of Section 5110. That's, the Federal Circuit may write things that I get confused by. That seems pretty clear. What possible basis do you have to say that the 8 judges out of 13 on the Federal Circuit said that, but yet you're telling us, don't worry, you can use equitable estoppel?
Because Mr. Lee's case can be distinguished from the facts in Taylor. In Taylor, the court spent a lot of time on Richmond, where discussing how the Appropriations Clause does not authorize a monetary remedy that Congress has not authorized. And there was also no statutory precondition that had not been fulfilled. But Mr. Lee's facts are very different from Richmond. In Richmond, the individual was seeking money that was prohibited by the statute. In Mr. Lee's case, the law granted 100% disability to veterans with leukemia. And under 38 CFR 17.33, doctors have a duty to give patient right. Mr. Lee had a patient's rights to receive prompt and appropriate medical treatment. That didn't happen in 2012 when that doctor withheld the term leukemia and told him that maybe in 20 years he would need further investigation. So that distinguishes.
How is the duty to inform the patient rule different than the outreach notice and assistance statute at issue in Taylor?
So, Your Honor, the outreach assistance statute was, I believe, 6303, and that had to do with the notifications given to service members when they're processing out of the military, I think. Whereas here, we are talking about the VA doctor's duty to care for his patients, as reflected in the federal regulations, and also as shown under the American Medical Association patients' rights, essentially their broad ethical codes.
So isn't it odd, though, that because the VA does a lot of medical treatment, right? And so it seems to me what you're saying is when there is a deficient medical care, equitable estoppel can apply, even though the Federal Circuit said in categorical terms that equitable estoppel does not apply to claim filing limits under Section 5110. It seems weird then that the Federal Circuit would have established what looks like a categorical rule that then we would say, but we're going to drive a Mack truck through because anytime there is deficient medical care, then we can apply equitable estoppel in theory.
Your Honor, I don't think it is a broad anytime there's deficient medical care. This is a very, very fact-based situation where the doctor deliberately withheld his diagnosis from him and told him not to come back. And he documented it in the record. That distinguishes this from just a general mistake.
Why? So if the doctor had looked at this and said, I don't think these are sufficient indicators of leukemia, so I'm not going to use the word leukemia, even to say, I don't think this is, but you should come back for more testing. Why is that different than what you're framing the issue to be here?
Mr. Lee already had leukemia when he sat before that doctor. His leukemia, the testing and the board found that the leukemia, the evidence of record shows that he had leukemia in July of 2010. This doctor in 2012 deliberately kept that information.
So you keep saying deliberately, but do we have to find what if is there a difference in your mind between a doctor who looks at this and says, okay, I could say he has leukemia, but I'd freak the guy out. And so my medical judgment is the arc of this is going to be for the next 2 decades, he should be monitored, but I don't want to scare him. And so he says, I'm not going to use the word leukemia. Versus the situation that says, this guy has leukemia, but I'm going to show him, I'm going to not tell him, right? Evil intent in one, not in the other. Does it matter to you, the difference between the two?
If we're talking about just merely a mistake or an error, I don't think we get to this issue of equitable estoppel.
Well, then throughout, including in your brief, it talks a lot about misdiagnosis and malpractice, not deliberate concealment. And certainly the board seemed to address it as a misdiagnosis claim or a malpractice claim, not a deliberate concealment. And what in the record do you point to for this notion of deliberate concealment?
Because he didn't use the term leukemia, and he documented the words that he didn't use. If the term leukemia didn't matter, why would he document that? It is that keeping that information when leukemia was 100% disability benefits, and that information was kept from Mr. Lee.
So it's malpractice for him not to have told him.
It could be a malpractice claim, but a malpractice claim is in a different court under different standards. Mr. Lee is simply seeking the effective date he should have had the doctor told him he had leukemia. and there's no other avenue for him to get that
Well,
than the VA process.
I guess this crosses over from the equitable estoppel argument to the constitutional argument, but the doctor didn't prevent him from filing a claim. Perhaps he didn't have enough information to trigger in his mind, gee, I should file a claim, but at any time he could have filed a claim.
Mr. Lee had never filed a claim, and he wasn't inclined to file a claim unless he knew that his Agent Orange exposure was connected, like the symptoms he was experiencing, fatigue and such, were somehow connected to his service in Vietnam. And that connection was not given to him because it was the leukemia, the CLL, that was the presumptive condition, not keeping that term away and then telling him to come back in 20 years.
So the Federal Circuit's decision, turning to the constitutional question in Taylor, it only has 6 judges who join the portion of the opinion that says that there can be an as-applied constitutional challenge to Section 5110. So it's not a majority. To be sure, there isn't a majority saying no. There's just a plurality for Judge Taranto's opinion. So why should we adopt the rule that says that Section 5110 should be subject to an as-applied constitutional challenge, other than the fact that we know that 6 judges on the Federal Circuit would come out that way?
Because even under a plurality, I believe this was in Texas, the case of Texas v. Brown, the Supreme Court made clear that even when it's a plurality decision, if it's not binding precedent, it is the learned opinion of these judges. And what these opinions, whether you look at the plurality or the concurrence here, what they look at is where I think the overlap between the plurality and concurrence, there's not a lot, but there is, if you have acts of the VA that or the government in the Taylor case, that intentionally prevent a veteran from filing a claim, the court can find a remedy for that. The Taylor court split on whether that would be estoppel or constitutional access as is.
Well, they really didn't split because 8 judges said there is no equitable estoppel and only 5 said there was, right? So just for me, I'm gonna work on the assumption that the equitable estoppel door is closed. I understand your argument, but so I'm going to focus on the constitutional question. So assume with me that we adopt Judge Taranto's framework, that it's possible to have an as-applied constitutional challenge to 5110, and that the undue interference, active interference that is undue, is actually the test that's done for access to an adjudicatory form. Let's just assume that that's the rule that we would apply. Why is, in your view, Mr. Lee's case one of the extraordinary circumstances that matches Mr. Taylor's, where you had criminal prosecution dangled out there, and was a truly unusual type of situation in the context of Mr. Lee, where we're talking about medical treatment that may or may not have been deficient?
Because there's no justification for what happened to Mr. Lee. It actually differentiates from Taylor. In Taylor, there was a national security argument as to why things were done the way they were done, and the veterans were prevented from accessing the court. But for Mr. Lee, there's no justification for
What if the doctor mistakenly thought that it was better for his patient to not worry him by using the term leukemia? He might have been wrong, and another doctor might have said, no, you should have said it. Why is that like Mr. Taylor's case, which is the only one that we know qualified for this unconstitutional treatment?
As a doctor, when you look at patients' rights and what that doctor-patient relationship, a doctor doesn't have a right to choose to withhold a diagnosis from a patient.
So, but why is that this could be the most unfair thing in the world. what gives the court the warrant in this case to say that that is a violation of the Fifth Amendment right to due process? I mean, it may be unfair, but why does it rise to the level? Because if this rises to the level of unconstitutionality, it strikes me there's going to be a slew of things that could possibly do that.
Because it was intentional. I think that.
Well, but you say it's intentional, right? Of course it's intentional, right? That doesn't say anything. So almost everything a doctor does is intentional. Right? It may be a mistake, right? I cut here intentionally. It's not, maybe I do it accidentally, right? But are you saying when you use intentional, are you saying that we have to find evil intent, right? Because after all, we're talking about precluding somebody from accessing an adjudicative forum. Do we need to have the intent that the doctor meant to prevent him from filing a claim?
I think you need to have the intent that he kept the information from him that would have enabled him to file the claim, which is
no matter what the reason.
I think there's not a reason or a justification in this case, and I think that's what sets
Why?
case up.
Why? What can you point to that says that this doctor did? What can you point to that tells us, if it's important, why it is the doctor chose not to use the term leukemia?
Your Honor, we've brainstormed this one around the office, and we can't figure out why a VA hematologist and oncologist would do this.
What about not scaring the patient because the doctor mistakenly thought that this was a disease that wouldn't progress? You see, because the treating doctor probably wasn't thinking about filing a claim. He's thinking about his patient. Maybe he's wrong, but maybe he says, I don't want to freak him out. And why would that then be a violation of the Fifth Amendment to the United States Constitution?
Because as a veteran, knowing you have leukemia and when you were exposed to Agent Orange tells you to file for benefits. When you don't have the word leukemia, you don't know to do that.
Well, Mr. Lee could have filed for fatigue.
Yes, but there was nothing to link his fatigue to his service in Vietnam. That's why he was in that office.
Well, but no, he wasn't in that office to link his condition to Vietnam. He was in this office for medical treatment, right?
He was in the office because he was experiencing the fatigue and he was looking for answers as to what was happening, why this was happening.
Right. And so why was it then to go to Judge Falvey's question again, that the doctor precluded him, actively interfered?
Because he had nothing Mr. Lee had never filed a claim. He had nothing to link the fatigue he was experiencing to his service in Vietnam when he was told the word leukemia wasn't said, and he was told maybe in 20 years you'll need further investigation. That's not even the standard for the treatment of CLL. CLL requires more monitoring. This kept the information, the veteran intentionally kept the information the veteran needed to go and file that claim and make that service connection, that connection to his military service.
Does the record tell us whether he was told that he had monoclonal B-cell lymphocytosis?
He was. The doctor did note that he used that term of art with Mr. Lee.
And there's another explanation in there for the doctor. He says that even if it is a leukemia, it's 0 stage, would just warrant monitoring. So there's some medical judgment involved in that. On top of that, the board essentially found this to be a misdiagnosis, not a deliberate withholding. And you're asking us to essentially make a finding that there's a deliberate withholding. How do we do that? How do we get to that when the board essentially says, as was argued by Mr. Lee, I understand not represented by counsel and all, but that this was a misdiagnosis, this was an error, this was malpractice. and the board says, yeah, misdiagnosis, we got it, but we can't change the effective date based on that. You got a tort, maybe. You've got malpractice. You have a FTCA claim, 1151 claim, but we can't change the effective date. The monetary relief you might get elsewhere, but not through this mechanism.
Well, and again, the monetary relief would be for the other losses that he suffered because he lost his job, he lost his house, he had to move to a different state. Those are some of the effects of not knowing that he had that CLL. But I think...
How? He moved from Florida to Tennessee because he didn't know he didn't have leukemia?
Let me state that a little clearer. They were forced to move to an area with a lower cost of living because with the fatigue, he was struggling in his employment. And eventually,
you're tying that to the doctor saying, exercising his medical judgment to not use the term leukemia.
If you don't know you have leukemia, you don't have that to take to your employer when if your energy levels are dropping. And Mr. Lee absolutely articulated in his writings to the VA that affected.
Why didn't you file then a claim under the Federal Tort Claims Act, where you might have arguably been able to get these, to try to prove that because the doctor did this, he ended up having to move to Tennessee because it had a lower cost of living? And I mean, why didn't you do that?
Is it? I see that.
You can continue. Two more minutes, Don. Thank you.
The Federal Tort Claims Act is a claim against the doctor in Florida for the other damages that would be. I'm not sure how you would prove that, but
I'm not either.
Yeah,
but you just told us that it's true.
We're here for the effective date because that gives him the benefits he should have had if that doctor had just used the word leukemia.
But under the Federal Tort Claim Act, but under a tort claim, you could also say one of our damages was the fact that he's got benefits now. He could have gotten it earlier. We'd like the monetary value of that difference. That's actual damages.
I would need to look into the Federal Tort Claims Act to see.
I'm just thinking of I'm just thinking of tort law, but that's an actual damage. What was the injury? The injury was I didn't know I had leukemia because the doctor, in an act of malpractice, didn't tell me. And now I know I do. I could have gotten this thing, veterans benefits, at an earlier date. I'd like it calculates out to. I'd like that as part of my damages, plus the cost of my relocation, these other things that you set out.
Again, Mr. Lee is here because he's just trying to get the effective date and the benefits that he should have had. And this is appealing this through the court was the mechanism that he saw to achieve that.
So are you asking the court to reverse the board's effective date determination or just to remand the case to the board to reconsider it in light of Taylor?
So we are asking the court to direct the VA to grant Mr. Lee the effective date he should have had had he been told he had leukemia, which would be at least July of 2012.
Do we also have to reverse the finding that it was a misdiagnosis?
I think there's two different parts to this. The misdiagnosis occurred in 2010, and I think the intent occurred in 2012. That may require a remand for the board to look at the intent behind those 2012 notes, but the court has the authorization, the authority under Taylor to direct that.
Anything else? All right, well, thank you. You'll have your full rebuttal time.
Thank you.
Whenever you're ready, Ms. Leahy.
Your Honor, and may it please the court. The issue before the court is not whether Mr. Lee is entitled to an earlier effective date under the governing law. There is no dispute that for Mr. Lee, Section 5110 authorizes an effective date no earlier than January 29th, 2016, the date that VA received his first and only claim. There is no dispute that Mr. Lee did not file a claim prior to that date. There's no dispute that he does not meet one of the 16 enumerated exclusive exceptions in Section 5110. And there is no dispute that Mr. Lee is already in receipt of the earliest possible effective date that the law authorizes. Rather, the issue here is whether the circumstances of this case, involving perhaps a misdiagnosis, at most medical malpractice, are so extreme, are so extraordinary that they constitute that most rare set of circumstances in Section 5110 would or could be found unconstitutional as applied to Mr. Lee.
So on that point, is the Secretary taking the position that the plurality position of Judge Toronto on the unconstitutionality point? That is that Section 5110 is subject in some circumstances to being held to be unconstitutional as applied, is correct?
No, Your Honor. The Secretary's position is that plurality opinion is not precedential, it's not binding on this court, and that there would not be circumstances.
I'm with you on the first part,
Yes.
Right? Because all you need to do is count, right? Yes. There's 13 and there's only 6. So I'm with you there. My math skills are rudimentary, but I'm there. But then the question then becomes, do we say, well, it's not binding, but there are situations conceivably, Mr. Taylor, for example, in which, yes, they're rare, in which it could be as applied, held to be unconstitutional as applied. Because if the Secretary's position, it could never be so. Why is that? Because an as-applied challenge really, says we can't imagine all the different situations, right? So I'm having trouble why we wouldn't say, sure, it can be, even if we then went on to say, but not in this situation.
I think that is certainly the fallback, but I don't know that there needs to be such a broad ruling, especially in this case, because I think that it gets down to just the facts of this case, and this certainly does not meet the extreme circumstances of Taylor here. So I'm not sure that the court would need to get to that question of whether there ever could be or couldn't be.
Well, it would be easy if we said,
yes,
despite what the Federal Circuit did in that plurality opinion of Judge Toronto, we're going to say that under no circumstances could there be an as-applied challenge, then you'd be done, right? You wouldn't have to look at the facts and circumstances. And so which view does the Secretary want us to try to take?
I think the Secretary, as the first position, would say that there are no circumstances, but I don't think that. But I understand that it's, in this world of hypotheticals, there may be some circumstances that could occur, Mr. Taylor, or even something more extreme than that.
If it's none, though, how does Taylor win?
I'm sorry?
If there's no circumstances, how does Taylor win?
Well, as Judge Allen alluded to with the math, there was not actually a majority of the court that found for the judgment that he ended up getting. There was 11 that ended up voting in favor of the judgment, but there was 5 that would have gone equitable estoppel and only 6 that would have gone constitutional. Right. So,
yeah, it seems to me that the only 2 rules to take from Taylor as binding are number 1, that 5110 is not subject to equitable estoppel, and number 2, Mr. Taylor wins. That really seems to me to be it. So, all right, well, let's just assume that it is subject to equitable.
Hello, Dawn. The time is 10:30 a.m. Currently in Washington, it's 71 degrees and cloudy. Today.
And that was our drive time break, right? The traffic is horrible out there. So let's just assume the Constitution could be violated in an as-applied way. Would it matter to your assessment whether or not, as the board describes this is a case of misdiagnosis, or as you said, perhaps differently stated, medical malpractice, versus not just an intentional choice, but an evil choice? right? In other words, the doctor sitting in his office says, I'm just sick of these people, and this guy has leukemia, and I know he could get 100%, but I've decided I'm not going to tell him, so he doesn't file. Would that then get this to the level where you would say it's unconstitutional?
No, Your Honor. I think that while the intent can be important in the sort of analysis as a whole with the right of access cases, I do not think that the intent is dispositive, whether he has this evil, malicious intent or not.
Doesn't Taylor say that there's no scienter requirement? That
Yes.
The only requirement is that the consequence has to have been foreseeable.
Yes. So I think that the intent would not be dispositive. So it could be that he had a malicious intent, or it could be that, as the board found, that it was just a misdiagnosis here. And certainly the record does not bear out that he had any malicious intent, but the answer to the question would be that the intent is not dispositive on that.
Go ahead.
Isn't the rule for plurality opinions that, though they're not binding, that they're a persuasive authority?
Yes, Your Honor, and the Secretary does not dispute that the Taylor plurality, the court could find that as persuasive authority.
And the Marx rule that the Secretary cites tells us to look at common denominators between the opinions, right?
Yes, Your Honor.
So here in Taylor, isn't the common denominator between the 6-judge plurality opinion that Judge Taranto authored and the 5-judge concurrence that Judge Dyke authored that VA cannot benefit from misleading a claimant to the claimant's detriment, whether the roadblock is unconstitutional denial of the right to access or equitable estoppel?
No, Your Honor, I don't think that that's the lowest common denominator. Ultimately, they both, though they took markedly different legal approaches to reaching the judgment, we don't feel that the judgment is the rule of law that should apply going forward. I think the Secretary's position the Secretary would agree with Judge Allen that the two rules of Taylor would be one, that it's a categorical rule that equitable estoppel does not apply to override the effective date rules of Section 5110, and then also that Mr. Taylor.
Well, Judge Dyke wrote that if a veteran doesn't know about his benefits, he will not file, and if he doesn't file, he doesn't accrue benefits, and that equitable estoppel is premised on VA misconduct. Mm-hmm. And that seems to correspond with Judge Taranto writing that VA's affirmative conduct unduly interfered with Mr. Taylor's right to access to adjudication of his benefits, so that Judge Taranto could accurately announce that a majority of the Federal Circuit, 11 of 13 of the circuit judges, in fact, agreed that when a veteran had been determined to be entitled to benefits, the required effective date was the date that the veteran would have had in the absence of interfering government conduct. Doesn't that capture what happened to Mr. Lee here?
So I guess, Your Honor, I'm not sure what the test would be going forward, what the legal rule, the principle there would actually be under what you've taken as the two aspects of equitable estoppel. If we think that there's equitable estoppel, and then the other judges who would reach the same result but think that categorically equitable estoppel cannot apply. I'm not sure what the court.
Both of them flow from the same conduct and
Yes,
the same. They obviously have different views of how to get there, but that's you already answered the question that is the common denominator between the two opinions.
That they ultimately came to the judgment, yes, but that does not create a rule of law to apply going forward, which is what I think that a lot of the circuit courts have discussed with the difficulty with the Marx rule. When there are plurality opinions and when there's not, in a circumstance like here, they take markedly different approaches, such that there is no common denominator, because it's really talking about the legal reasoning and how they get to that result, not the bottom line result itself.
Well, it's still the 6-judge plurality opinion that matters, but. They both matter, but it matters more. But it gives, in my opinion, it gives the plurality opinion a lot more oomph than it might have in circumstances where there truly isn't any agreement on anything but the outcome. We've had that happen on our court.
So in that circumstance, that would be the rule of law, is that there could be, that Section 5110 could potentially be subject to constitutional due process, right of access violations. And even if that is the case, that these circumstances here involving, as noted, a misdiagnosis or medical malpractice, they certainly do not rise to that extreme, that extraordinary circumstance of Taylor, where the 6 judges, the plurality, found that that Section 5110 was unconstitutional as applied.
What element of Taylor is not met here?
In terms of the right of access, the plurality's opinion, the undue, certainly it's not undue interference. I think that, I believe it was Judge Hughes that was discussing the case law around the right of access doctrine is not very clear, but just using, the plain meaning of the word undue, excessive or unwarranted. There was not excessive or unwarranted conduct here. There was not interference with Mr. Lee's right and ability to file a claim. He could have at any point filed a claim. He could have, as Judge Allen noted, filed a claim for benefits for fatigue or for the diagnosis that he did receive in 2010 for monoclonal B-cell lymphocytosis.
But it's reasonable to expect that if you withhold information that a patient has a disability, that patient won't file a claim, because after all, to get disability compensation, you have to have a disability, right?
Yes, Your Honor. Ultimately, yes. But he could have filed, again, a claim for what he knew that he had, which was fatigue, which was this monoclonal B-cell lymphocytosis, MBL for short. At any time, there was no conduct here that completely foreclosed him from filing a claim for benefits. And I think that as Mr. Lee's counsel discussed, it was Mr. Lee's choice not to file because he apparently only wanted to file a claim when he already knew that he was going to be entitled to benefits.
Doesn't the Arellano holding that the 5110 exceptions to setting the effective dates of an award of benefits at the date of application are not simply time constraints, but substantive limitations on the amount of recovery due, emphasize what the veteran lost by being misled regarding the nature and extent of his condition, and thus belie the Secretary's argument that the veteran ultimately gained access to the full scope of benefits allowed?
So I'm sorry, Your Honor, I think I'm having a little difficulty following. Because the Supreme Court discussed that the Section 5110 it's a substantive rule, then that.
So it's a real loss when you
Yes.
lose 4 or 6 years of effective date.
Yes, Your Honor, and as I think discussed earlier, that could be a claim for or that could be an aspect of a claim for damages under a tort claim, medical malpractice, FTCA. There certainly is a loss in that regard. Those are benefits, but unfortunately, he's not entitled to those benefits here.
But there's a lot of speculation regarding what could have happened, but we have an actual record, and that's the one we have to decide the case on.
Yes,
We
Your Honor.
have what the doctor said and did, and so we could speculate about his motives and intentions, but there's no evidence of that, and no effort by a regional office or the board to ascertain what that was or make any findings in that regard.
Make any findings in what regard, Your Honor?
In regard to what happened here, they don't address it at all. They care with respect. They characterize what was happened as a misdiagnosis.
Yes, Your Honor.
But make no explain. Don't what's their where's the explanation by the board, the reasons or bases for rejecting the favorable evidence? That the 9 times, I think it was, and I found in the record that the veteran complained that he hadn't been told.
Mm-hmm. I mean, I think that the board did note this in its prior February 2021 opinion or decision, I believe. That's properly the subject of a medical malpractice, an 1151 claim. The facts here are distinguishable from that, and encouraged him to apply for benefits under 1151. And Judge Allen in the prior MEMDAC also noted, that the appellant had not challenged any aspect of the board decision in that regard, and that the court found no error in that regard. But I think the board also taking the facts as.
But the fact that he can file an 1151 claim for misdiagnosis and malpractice doesn't really have anything to do with what the effective date is for his disability claim. Nothing.
It does not. There is no provision, there's no exception in Section 5110. Congress has not created a remedy for these facts here. And that it can be sympathetic, it can be unfortunate that he was not told, that he was told what that doctor in 2010, and then again in a different VA oncologist in 2012 did not use the word leukemia, but that does not mean that he is entitled to a remedy here, that he's not. The governing law is clear. The effective date is the date of claim. And that's what he has here. So the Secretary's position is that there was no active undue interference. The government did not violate Mr. Lee's right of access. And even if it had, the court would have no equitable or statutory authority to remedy such a violation here. The Secretary would also note that, just in terms of the facts, MBL and CLL, what he was actually diagnosed with in 2010, and then he is diagnosed later with the CLL in 2016, those are very close conditions. That, as Appellant notes, I believe in a brief, that MBL is a precursor to CLL, and there could be any number of reasons why that the pathologist in 2010 felt that he did not meet the criteria. Certainly the VA treating physician that wrote the letter in 2020 only took an excerpt of a sentence from that lab report and left out the pathologist's finding that in the absence of extramedullary involvement, he does not meet the criteria for CLL. But regardless, the treatment for that is the same. It is just this watchful waiting and an annual blood test, complete blood count with differential. And he had that. He had it in 2009, 2010, 2011, 2012, 2014, 2015, and 2016. He was being monitored. So the facts here, I would just point out, are certainly, even in their worst light, that he had this 2012 VA physician had this evil intent. They still do not establish that these are these extreme circumstances, extraordinary circumstances, very rare set of circumstances that the 6 judges on the federal circuit found could be a constitutional violation of his right of access. The Secretary would also emphasize again that the equitable estoppel, it is a categorical rule by a majority of the court, and that Mr. Lee is not entitled to relief under that doctrine. He has also not demonstrated that even if Section 5110 could be subject to this constitutional due process right of access doctrine, that his circumstances meet that. There are no circumstances here that resemble this sort of systemic government-wide interference with access to the VA adjudicatory system. There was no penalty to him for filing a claim. There was no conduct by the government that was otherwise undue. So the Secretary would ask that the court affirm the board's decision.
Thank you very much, Ms. Healy. We'll hear rebuttal, and as I said, you have your full 10 minutes.
Thank you, Your Honor. Just really quickly, a couple of things. Going back to the intent of that doctor, he said maybe in 20 years he would need further investigation, not come back in 1 year for an annual monitoring. He scheduled no test, scheduled no follow-up. Come back in maybe in 20 years. That shows an intent to mislead the veteran. Regarding an 1151, an 1151 is for an additional qualifying disability. It isn't for the service-connected CLL. Rather, it's an additional qualifying disability due to VA malpractice. It doesn't get us to the heart of the effective date for his CLL. And MBL was not in the rating schedule in 2010 or in 2012.
So could I ask you a question? Just assume if we were going to rule in your favor, what limiting principle would you have us write down in an opinion that would not sweep in any case in which a doctor failed to provide what later turns out to be correct medical information?
Yes, Your Honor. I think you can. It is putting the intentional misleading in a documented in writing. The 2010 lab report looks like it's a VA lab error because it talks about the numbers.
And so is that unconstitutional?
No, Your Honor. I think it's when you get to that intent. And here we have that.
So you keep saying intent. Intent to do what?
To withhold his information, the information about the leukemia, so he didn't know to file a claim.
So those are you've built two things in there. Are you saying that to reach the Constitution, the doctor here would have to find as a factual matter that he intended to withhold the information in order to prevent Mr. Lee from filing a claim?
No, Your Honor, I do not believe it would have to be. It's the intent. It's the intent.
Yeah, but you keep going back.
The reason.
The intent to do what? The intent to not use the word leukemia is enough.
To withhold his diagnosis from him, to withhold the information about his condition that would give him the full information he needed to make a decision about whether or not to file a claim.
And so, in your view, does it matter what a medical professional knows about the claim process?
I don't think so, Your Honor, because the job of the medical professional, they can't be expected to follow all, unless they're doing the exams, all of the rating schedules. But it is their job to fully inform the veterans so that they can move forward of their conditions, especially when you have an Agent Orange veteran in front of you who has an Agent Orange connected leukemia. So it is their job, it is their duty to fully inform the patients so that they can make decisions about their care, and then they can make decisions about filing a claim because they have that link. They know that leukemia tied to Agent Orange.
When you say that the doctor withheld the information, the doctor put it in the medical record. So he didn't, when you say withheld, didn't tell him orally.
Yes, Your Honor.
But he documented it in the record so that, stuff's put in the record for the doctors, so the doctor can recall it, so that the other doctors down the road know what happened, transpired, so that the patient has a history of what transpired at any given consult. So there's lots of different reasons why the doctor, would have put in there that I didn't tell him that this is categorized as leukemia. But it also cuts against it was withheld because it was put in the record. It wasn't that this was stumbled upon later when the doctor was giving an interview or was questioned or something like that. It was put in the record. And by being in the record, it gave Mr. Lee evidence that he could use to advance a claim. So this goes back to the limiting principles. What's the limiting principle here that is going to not cause this to become a open-ended, anytime a doctor withholds, under that very broad understanding that you apparently have, medical information?
I think the limiting factor may be that there's no reasoning in that record as to why you would do this, why this doctor would do this. It's not, I didn't tell him because there's no rationale in there. There may be medical reasons why, in a hypothetical situation, why a doctor would need to withhold that.
So are we sending this back then for VA? If we were to agree with you that yes, a constitutional as applied challenge can be made. Here's the rule: if you withhold information, and then send it back for VA to explore whether or not this information was withheld under whatever standard we develop.
Yes, Your Honor. I think that would be the solution in this case, is to send it back down for the board.
They could send it back to the doctor for explanation as to why this information was withheld, and if it's a good reason, and the constitutional challenge falls apart?
I'm not sure what the VA internal procedures would be for that, but I guess in theory they.
Well, there's got to be findings of fact. We can't, there's got to be, I would think there'd have to be some findings. I mean,
Yes.
you said it's withheld. That's the standard. Intentionally withheld.
Yes.
They've got to find out, was it intentionally withheld, right? Somebody's got to find that fact.
Yes, Your Honor. Yes, Your Honor. And I think that could be done at the board or I guess if there's a mechanism for the RO to do that, I'm simply not sure.
And okay.
Basically, just to summarize, Mr. Lee was a combat veteran who served in Vietnam. Prior to his deployment to Vietnam, he voluntarily extended his enlisted obligation by 3 months in order to do his duty and remain with his unit through the Vietnam tour. But decades later, the VA failed in its duty to care for veterans like Mr. Lee when it didn't tell him he had leukemia for almost 6 years. The Taylor holding allows the court to grant Mr. Lee an effective date he is entitled to. And we would ask that this court either hold that the VA's failure to tell Mr. Lee he had cancer for almost 6 years violated his constitutional right to access the VA adjudication system, or remand and grant Mr. Lee an effective date of at least July 2012, or remand for the board to consider under that holding. Thank you.
Well, we thank counsel very much for your appearance here this morning, and we will come down and greet counsel. The case is submitted.
All rise.